This is DevAI, focusing on the newest developments in AI and the legal space. Please subscribe to my channel. The new AI Act proposed by the European Union is already causing some challenges ahead. The European Parliament's co-rapporteurs proposed compromise amendments to the list of high-risk AI applications, banned uses, and concept definitions. EU lawmakers Brando, Benifei, and Dragoș, Tudorache are striving to close the negotiation on the Artificial Intelligence Act in the coming days. The Act is the world's first attempt to regulate AI based on its potential to cause harm. Among the pending issues the two lawmakers are trying to close is the list of AI uses that pose significant risks, the prohibited practices, and the definitions of the key concepts used in the draft law. The major question concerns high-risk areas where the AI Act's Annex 3 lists critical areas with specific use cases. In the compromise version of Annex 3, the extended notion of biometric identification and categorization to biometric-based systems like Lensa, an app that can generate avatars based on a person's face. The objective is to have live biometric identification in publicly accessible spaces to be banned altogether. The high-risk use case has been limited to the exposed identification. For privately accessible spaces, both live and exposed identification have been added to the list. Moreover, the use cases include remote biometric categorization in publicly accessible spaces and emotion recognition systems. For what concerns critical infrastructure, any safety component for rail, road, and road traffic has been included. However, systems meant to ensure the safety of water supply, gas, heating, energy, and electricity would only qualify in this category if the system's failure is highly likely to lead to an imminent threat to such a supply. In the education area, the wording has been amended to include systems that allocate personalized learning tasks based on the student's personal data. In the field of employment, the high-risk category was expanded to include algorithms that make or assist decisions related to the initiation, establishment, implementation, or termination of an employment relation, notably for allocating personalized tasks or monitoring compliance with workplace rules. Regarding access to public services, the text now specifies the type of public assistance the provision refers to, namely housing, electricity, heating and cooling, and internet. The exception for systems designed by small providers to assess people's creditworthiness has been removed. AI models intended to assess the eligibility for health and life insurance and those to classify emergency calls, for instance, for law enforcement or emergency healthcare patient triage are also covered. A new risk area was added for systems meant to be used by vulnerable groups, particularly AI systems that may seriously affect a child's personal development. This vague wording might result in covering social media's recommended systems. Lawmakers expanded the wording in the law enforcement, migration, and border control management to avoid the high-risk classification being circumvented using a contractor. Moreover, an AI application that could influence people's voting decisions at local, national, or European polls is considered at risk, together with any systems that support democratic processes such as counting votes. A residual category was introduced to cover generative AI systems like ChatGPT. Any AI-generated text that might be mistaken for human-generated is considered at risk unless it undergoes human review and a person or organization is legally liable for it. AI-generated deepfakes, audiovisual content representing a person doing or saying something that never happened, the high-risk category applies unless it is an obvious artistic work. AI-powered subliminal techniques for scientific research and therapeutic purposes are also at high risk. Another important part of the AI rulebook is the type of applications that are banned completely. AI models using subliminal techniques beyond a person's consciousness are to be banned, except if their use is approved for therapeutic purposes and with the explicit consent of the individuals exposed to them. Also prohibited are the AI applications that are intentionally manipulative or designed to exploit a person's vulnerability, like mental health or economic situation, to materially distort his or her behavior in a way that can cause significant physical or psychological harm. The co-rapporteurs are proposing expanding the ban on the social scoring not only of individuals, but also the groups of inferred personal characteristics that could lead to a preferential treatment. The ban on AI-powered predictive policy models was maintained. The definition of AI is a sensitive topic, as it determines the whole scope of the regulation. This part has been parked for the moment, according to a comment at the margin of a third document. The concept of risk was defined as the combination of the probability of an occurrence of a hazard causing harm and the degree of severity of that harm. More definitions have been added concerning data, profiling, deepfakes, biometric identification, and categorization, as well as subliminal techniques and sensitive data, which brings more clarity to these concepts and aligning them to the EU's General Data Protection Regulation. The regulation will still undergo some significant changes, and with the rapid development of new technologies, there will be even faster updates. This is the FAI, focusing on the newest developments in AI and the legal space. Please subscribe to my channel and put any questions or feedback in the comment section. Goodbye.